We'll call to order the City Charter Review Committee meeting of Thursday, October 17th, 2024. Rebecca, special thanks for you being here tonight. If you please call the roll.
Diane Gadaris,
Present.
Jeffrey Hank,
Present.
Jonathan Foreman,
Present.
Dr. Ruben Martinez,
Here.
Jill Rhodey,
Here.
Pam Weil,
Here.
Dr. Veronica Wilkerson Johnson,
Present.
Dale Creidoff,
Yeah.
Lynn Richardson.
Okay, we'll move on to item 1.2, approval of the agenda. Is there a motion to approve? I'll move it. So moved by Pam Weil, supported by Dr. Wilkerson Johnson. And any changes or additions? Okay, all in favor say aye.
Aye.
All opposed, same sign. The agenda is approved. 1.3, approval of the minutes. I'm going to move approval with a small correction, and that is under old business. The second paragraph, Chair Gadaris discussed the map of East Lansing that shows the boundaries of the, I'm going to add the northern area of the city because we didn't have the entire city on there. So the map we were using is just the northern area of the city, and then including 425. So I'll move the minutes with that correction. Is there a second?
Support.
Supported by,
I've got an additional correction.
supported by Dr. Wilkerson Johnson. Go ahead, Pam.
It was Jonathan was making the point of 3.4 and the reasons for removal. Just for further discussion, I don't think you had it. And then I was the one with the oath issue.
So what would you like it to read?
Well, I think it should be Pam Wild requested more information about the 3.4 charter taking the oath. And would you say, Jonathan, you requested more information or you just brought up a concern for future discussion?
I think it's just I was flagging it for future discussion and that any the questions I had were answered by the city attorney.
In the meeting?
Yeah, in the meeting. Yes. I had some preliminary questions about what an operation of law looks like, and I think Mr. Chubb addressed those in the meeting.
So how about if it reads, and while asked for more information about section 3.4 of the charter pertaining to the oath of office, and Jonathan Foreman asked for additional information?
I think that's a fair.
In addition, but that implies that it's about the oath. Pam Weil brought up concerns around the oath of office. John Corbin brought up concerns around the vacancy. I had a concern about F, and you had a concern about A through E.
The section as a whole, yeah.
A through E of what chapter?
3.4. And I had just F. So you started it, and I thought about that one.
Okay, so it'll read Pam Weil asked for more information about section F 3.4.
3.4 point F.
3.4F of the charter pertaining to the oath of office, and Jonathan Foreman brought up concerns of 3.4A through E. Okay, those corrections. All in favor, say aye. 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 All opposed, same sign. The minutes are approved with those corrections. Okay. So our communications from the audience. Don't see anyone here. So we'll pass on to communications from committee members. And I'm going to start with just a few things that I want to go over, and then we'll go see to the rest of the committee. First thing I want to say is I did talk with the League of Women Voters, and they did make an announcement before their virtual meeting to discuss Proposal 1, that we were not sending out anything regarding this, and that our committee is separate from the committee that was supportive of Proposal 1. I went to the city council meeting on Tuesday, and I did that same clarification during citizens' comments. And also then reviewed what's on the website for people and how they can get the schedule and everything, and then they're welcome to attend. And directed them there to our email address as well. And then Asia and I have been going back and forth about setting up the agenda each week, and rather than having a conversation each week, since we already planned our schedule out, I think tonight's agenda is sort of reflective of how we'll go, except on the nights when we have public comment, just so that we always have communications first and from you as well. And then our new business will be what's on the schedule. That's listed on our website, and their old business will just show what we're, where we're at with what we're reviewing, and take a moment to make sure that we're all on the same page about needing any information for our next meeting when we're discussing the next chapters of the charter. And then the last thing is there was some discussion about a preamble during our meeting. And how about if we add that to the end of our calendar when we're all done reviewing the charter, if we look back and say, do we want to put a preamble there and discuss it? Thank you, Jeff, for some of the examples, and we can discuss those back at that time. So those are my sort of announcements, and if that's okay with everybody. That's the way
Can
we'll
you send
proceed.
some examples?
Yeah, I think preambles should be on the table tonight's discussion as part of it. I mean, all the charts I looked at, the preamble is the first thing comes before chapter 1. So just, not that it can be addressed later, and just, I was gonna mention that tonight, that, looking at some things, that's, typically where it goes.
My question was, for Tony, are we allowed to change the format of the document? Because I know sometimes that's why you leave 4.2.1 blank, because you can't get rid of it because it changes all the other numbering. So I wonder if there's if that's a structural issue that might require us to go to a commission.
I don't really see any concerns because, like, Jeffrey has sent out the Lynn City Charter as revised, which does have a preamble with a Bill of Rights, and that's one of the ones that I worked on. And that doesn't change the numbering, but I think what the chair is saying is that it might be best to get through the entire document to see if, after all the proposed changes, there are loops or still holes in it, which would merit going back and having that preamble, so I not speak for you.
Well, and I think in fairness to the rest of the committee, a lot of people might not have gotten your email today that shows some different things. So I think there's no problem with you bringing it up under your communications to talk about that. But for us to decide something tonight or to have discussion, I would think, I'd want everyone to have a chance to read it and think it over.
Absolutely, I just ordered an example, obviously, it wasn't meant to be like, let's do this, just, for consideration, like Grand Rapids, that's really lots of sections. And that, again, you can go on a numbered section. Where that's, it sounds like it would be disruptive.
Other communications from committee members side. Anyone else have anything to add?
I do, I don't see the ranked choice voting stuff. We did pass that, right, last election, right? So I don't think the city charter has that in there. Is there a reason for that?
It's a good point. That is the most recent version, as I provided as well, does not have it in it. I will look at that. That needs to be put that in or properly codified. It has been recognized as a result of the outcome of the vote, but it does need to be reflected.
So I attended the ranked choice voting meeting at the library the other night. East Lansing is one of 5 cities that has passed it. There's debate about whether the state can allow it. So just, it's a matter of interest, obviously, probably over the course supported it. And, at some point, I didn't know what section it was in. So I don't know if we should pick on the agenda right tonight or not. Other night. So do we know what section that is in?
It's my recollection that both it and the charter amendment that's on the ballot this November are both in miscellaneous in section 2.3. Is it 2.3? Okay, so I believe the ranked choice was set in chapter 20 is my recollection, but I'll make sure of that. And if it for some reason it's earlier and you missed it, we can go back.
All right, anything else?
I want to confirm that the email I sent and any other email communication be included in the website for the.
It'll be included in your next agenda packet.
Okay.
Because it came after we issued the
Okay.
agenda. So any communications that
Okay.
come after will get included in your next meeting.
Okay, that's it.
Yeah,
I just want to
it's-
make sure that we're keeping in the open meeting where everything is being shared.
Yes, it will be shared.
Your email to me, actually yours was in my spam.
No, I'm sorry.
And no, that's because I wouldn't, I almost didn't notice it,
Sure.
worry about clicking on it.
Right, well, I was,
Legit.
right,
And
and
I responded and I hope everyone got what I said. I know it's short note, I wasn't expecting everyone to digest it, but I just thought.
yeah, so that shouldn't really matter because it should be distributed. All of our communications should be distributed.
And they will.
Anything else? Okay, we'll move on to new business. We're gonna get into the charter now, chapter 1. So what I'd like to do is, actually, Dr. Martinez brought it up to me, that was a lot of reading with the, all of the ballot proposals that were from 97 that were sent out, that were just lots and lots of documents. And it is hard because there's so many there. So what I thought I would do is when we get to like what was changed, like let's use chapter 1.1. What was the change that was amended in 97 so that you have a little understanding of why it was changed, what was there before. And as we go through this each time, I'll do that. You're welcome to, you can read it ahead of time and I looked ahead for the next meeting, which proposals you should look at for the next meeting, the ballot proposals. But I did it for today, so I can start with this first one, just by prefacing that, there were 13 for chapters 1 through 3. There were 13 ballot proposals that came out of this. And since we're going to start on 1.1 boundaries, this, section 1.1 and alterations of boundaries, the charter was changed because they removed the historical description of the boundaries of the city that were from 1944 and references to statutory methods of boundary adjustment and just provides that they may be adjusted any means but that are provided by the law. So the law will dictate it. You don't have to put new boundaries in the charter every time you do something. So that was really to make it really more broad than the specifics that were in there originally. And then one ballot, that was ballot question 2. I didn't see any ballot question 1 in our group, so something else must have been on the ballot. But question 3 was the election precincts. And they changed that from being by ordinance to reduce the administrative delays and costs when changing a city election precinct. And I just wanted to say, just in general, so that you understood that when you have an ordinance, you have to read the ordinance at one meeting, then you have to have a public hearing, there has to be posted, and you have to react. Whereas a resolution they could do and an exam much more quickly and get it to the people that need to change their precinct for voting, change their location for voting. And one of those things that happened, most recently was Shari Zedek was a location for voting. And then there were concerns about safety. And so they had to move it to another place quickly. And going through the process of an ordinance would have been very cumbersome in the time period there. So that's a perfect example of why that was helpful to be changed back in 97. And that's all in chapter 1. So I'll just start tonight each time, just telling you what was changed and why, so we don't go backwards, which I don't think we ever will, because the charter was pretty meaty before we put this screen on. So, anyone want to start on boundaries, or let's do 1 through 1.4, anything you have on that?
I'm wondering if the single ward is also means, and I don't expect a group to follow me on this one, but I would like to see district representation for the city council, to make some combination of at large and district voting. But I don't know if the one ward means the place where that would have to be changed, or if it goes in the next section.
Well, right currently, there are 17 precincts. And we are considered one ward. Everybody is an at-large person. And so.
Is that because we have one ward though? So everybody's,
Right.
one ward means one at large. So that's why I flagged that. We can discuss that in the other next part. And I also just want to say that I think there's a real issue with us voting in churches. I understand that they're the buildings that are available to us. I would wish that we could have public buildings would have built the schools, which I tried to advocate for in such a way that there could be public access for voting. It's people with issues with the church, the possible undue influence of being voted in the church seems founding fathers. I would expect that to change.
So, let's go back, the location of the precincts. I can give you just a short version of that from the city clerk. There are 17 precincts right now in the city of East Lansing. And they changed the law that the precincts can be larger, up to 4,999 voters can be assigned to one precinct. The city clerk now is finishing her term, her employment at the end of the year. There'll be a new city clerk. The new city clerk could take that and change from 17 to 10 based on our population that we have in the city. So if we have a concern about that, we can pass that on to the city clerk. It won't be for this election, but to pass that on as something as an outcome of this group. So how about if we put that on? I can't remember what they used to call those. The whiteboard. So I'll try to keep track of that too, about the precincts and churches, and we can have more discussion on that, since that's not really in the charter, but just as a recommendation.
And that was my other question too, is the population, how are they distributed? And so that's a state guidance for how many per precinct that actually comes from the state government.
And be up to that. They changed it. And they changed it. I did a lot of research. They changed it because now they have early voting when so many people, you didn't have to be an absentee voter who couldn't make it to the precinct that day. Now you have early voting, you can vote anytime during that time, and you don't have to have a reason for early voting. So they don't feel like they need to have as many precincts, because people aren't all going to be packed there on one day. So that is definitely something that could be changed in the city as we go forward, just for their sake too. Yeah, for staffing. Oh, yeah. Okay, so the question on the table from Pam is one ward versus splitting up the city. Does anyone want to comment on that? And maybe you should give your rationale why.
Well, I did a little bit of research that I included in my email, the history of wards at-large voting, and the history of at-large voting really is the article Metro Times. Detroit went to at-large in 1919 when they realized a number of reasons that they're articulated the article, but one of the reasons was that they'd have a black person on the council because it was a segregated city, but inevitably end up with, and Detroit is not the only going from district representatives to at-large to avoid certain populations getting councils. So that catches my eye. I ran for county commission, so as a citizen running for office, it would be much less expensive to have a smaller constituency, which I think would open that possibility up to a lot more people to possibly run for office. And then the model charter stated residents feel closer to district elected councils whom can be held responsible for addressing their community concerns. So that's just, you know what, yeah, it just feels like it might bring more amateurs into politics, and I think that would be good for, you know. So.
Other comments to that?
I have a question actually about like the would that like pertain only to the city council? Like in terms of the implications of that, or would it have like wide effects like during an election?
Well, one effect it would have is how the precincts are set up. Because if you had, like, right now, currently on the 17, one precinct is set up that it's all Clinton County. That votes in that one precinct. And so if you had a ward that crossed the boundaries of that precinct with another one, then you'd have different, you would have to look at what that meant for those people because you'd have different constituents in the same precinct from different counties, voting that way.
But in this case, it would just be for the elected officials for the city of East Lansing, which is just city council.
Wow. Okay, yeah.
Yeah, not judges or.
Okay, yeah, that's what I wanted to know is like what offices would
No, it would
actually
be
affect it.
yeah, no, it would be a city council changes, but.
Go ahead, Dr. Martinez.
I appreciate the suggestion, and certainly we are free to recommend that we go to the districts. I think historically, it isn't an issue of discrimination. I don't see it here in East Lansing because there was an expert witness on some of these issues. The Supreme Court has ruled that certain criteria that must be met when addressing discrimination.
Yes, but that's because East Lansing was completely restricted. We don't have a black neighbor because black people couldn't live in.
For whatever reason. In order for it to engage discrimination part, you have to have a concentration of a particular population that has historically been discriminated and they have not been able to elect a person of their own to the council. And then there's a whole set of other issues. So, I mean, certainly free to come up with districts, but I don't think that the rationale would be to address issues of discrimination.
No, I just share that rationale as an interesting insight. And I see the same functionality from a racially segregated neighborhood to a neighborhood that has particular interests and concerns because of its geographic location, particular culture and characteristics of which we definitely have here. Yeah. So that's.
So where are the different concerns? I'm trying to understand what you mean by that.
Well, Bailey has a lot more direct contact with students and Grand River businesses versus White Hills, which is more distant. And Glen Caron has a culture and characteristic that is different because of their position near Brandor and the highway. And we definitely have neighborhoods that have different house prices. And
Other comments?
If I could just ask a point of a clarification. So if we were to have 3 wards or 5 wards or whatever, the students would, the MSU campus would essentially be a ward of its own, or would overlap with some of the with the neighborhoods that neighbor MSU. Would that be? Am I assuming that correctly?
Well, I think that's the next question would be, how do we decide?
Yeah,
How do we split up the wards?
How many wards do you have in council?
yeah,
Are we doing it geographically? Are we doing it by population? Are we doing it?
neighborhood association, but then maybe also a couple of at-large seats, because that expands the number.
Does anyone, do the wards have to be generally equal population?
Yes, so the words have to be, is placed into a charter that you move to district representation or hybrid district representation, then the actual determination of the wards themselves, the physical location of them is subject to review after every census. And so that portion wouldn't be dealt with in the charter. It would just acknowledge that there will be, for example, in Highland Park, they went to 3 wards with 2 at large over their 5. Or it would say 5 wards or
But
whatever.
did they go from all at large to wards, or
They went
to
from
ward?
all wards to 2 at large, actually.
Ah,
Like Lansing side, Lansing has that large numbers.
Yeah.
Board members, yeah. And just like you said, I hear the people were supportive. you have a ward, it's less expensive, maybe you have someone who knows more responsive to your local concern. But then I've always heard historically this issue, that the student, as essentially that guarantees the student representation on council because the ward is there. Some people think it's a good thing, some people don't, you know, I don't know. It's a discussion.
It's only one person.
I'm sure Mark's got it.
Yeah, is this on? Can people hear me?
Green light.
The, there was a petition and a ballot proposal to go to wards. I think it was determined in either 1999 or the early 2000s. You might want to check on that, Tony, but my memory is that it had 2 wards and 3 at-large seats. It was overwhelmingly rejected by the voters in the city. There was a lot of discussion with regard to it. Generally, the pro discussion centered around the idea that you have a member of council who's beholden, I guess, to a certain geographic area of the city. There probably was a mistake proposed, because my memory is the proposal sort of split the campus in half, and the 2 wards were dominated essentially by the student population. That was proposed, and that might be the reason, it was not popular in the community.
That might have had to happen
But
because of the
let me finish.
population.
The other, just part of the discussion was that council members who are elected at large have a responsibility and a duty to everyone who's in the community, and that was more valuable than having somebody who might only have a responsibility to a certain area of the city or a geographic area of the city. So that was the nature of the debate that took place at the time. The ballot proposal failed, and we haven't really had a discussion about this since that time. So it may be time to take a look at it. Although I'll just say we were somewhat considered to be a somewhat larger city at that time. And certainly when you get to the size of Detroit or maybe Grand Rapids, you're looking at places where just to make it useful, you have to have wards, just like we have congressional districts and other places. That's a good one.
Well, and I think talking about the requirements coming from the state and that oddly structured ward system, that we might get the same thing again if we've got the 45, or whatever, so it's over on campus versus the city population, that we may not be able to draw my fantasy wards with aligning with the state laws of population.
Yeah, I think roughly we are at 22,000 semi-permanent residents, and the remainder are students at Michigan State Board plus.
I guess I'd be interested in knowing if there are sections of the city, neighborhoods, whatever, that members feel they're not represented in those.
I agree with that question. I'd be curious, since the neighborhoods vary in sizes too, whether you're talking about Conquest or Shaw Estates or whether you mentioned Bailey, and they're more contiguous to the campus, and population changes in the summer, as we know. So there's a lot of variances here, and it would be interesting to see if we have to have a certain number or.
Yeah, I was kind of picturing the neighborhood associations, the different neighborhood associations.
Yeah.
Groups that are meeting and bring their common cause to the mayor on a regular basis.
So that question would be really helpful then on, of our various neighborhoods, if they're even concerned that are related to, and how do we address that then?
I was gonna suggest not going like solely based on neighborhoods. I saw like a map of how like the neighborhood association actually defines, like at least in terms of representation, the neighborhood association, like some areas of the city actually fall between the lines of like what particular neighborhood is like defined as. So they're not like included in any neighborhood at all. What I saw on that.
Yeah, everybody should be in an association.
No, they aren't. just so you know.
That's not cool.
So I'm gonna add, just as a person who's been on council, and I'm sort of a geek about watching council meetings, much to my husband's dismay, every night that they're on. And I have seen over the years that some people are discussing something and they don't know where it is. And that always concerns me as a resident, that someone didn't go out and look at.
Oh, you mean someone on council?
Yes, and that happened on the planning commission too, to be discussing a planning commission, something that was really important to the business or to the rezoning or whatever, and members on that body had not even looked to see what the terrain was like, what was there. One of the recent comments was, now where is that coffee shop? And I'm thinking, it was passed 6 months ago, you passed it. So I'm very frustrated when I see that. And so I personally don't want to see smaller numbers, smaller groups represented, because I feel when you go on council, it's your obligation to know that city, to know the boundaries, to know what's going on in Bailey, and going to those neighborhood associations. And, we had neighborhood associations meet with the mayor, so that they bring their concerns to the mayor. And so not only does the mayor know that, but all of the neighborhoods, and then the mayor hears that, they bring that to the council. So the structure right now has been sort of that way and working. I would be hesitant, because I've seen it, people are busy, I give people a lot of passes sometimes that you didn't get over there for that thing on the agenda. But it doesn't look good to the person who wants the change, or who has went through the process and paid money to go and have this hearings, to have somebody asking questions about the site when they didn't go look at it, and you're gonna tell them what they're gonna do. So that's just from my geekiness in watching this, and knowing what I had to do as a council member and planning commission member to make sure you understood what's in the city, and thinking that you're making this decision for everyone, not just for that little group. That's hard. So that's the hardest thing about being a
I was
council.
at the Bailey meeting this week, and there was definitely appreciation for Eric Allman bringing Bailey concerns to the council. And the fact they felt that because Eric Allman is on the council, they have to represent it. So,
Yeah, Pinecrest felt that way too. But
right, so there is a neighbor aspect if someone happens to be a neighbor, so.
Didn't we voted recently not increase the size of council,
Yes.
correct? Right, so if someone's, Pam, or you, anyone curious, if anyone supports this idea of switching to wards, you view that as you have to increase the council member size, because I heard what Mark just said about 2 wards, like that doesn't make sense.
Yeah,
That model doesn't even
Right,
sound attractive.
And depending on the state restrictions or requirements for population, I envision, yes, that would be more. And that would also, to me, Diane, and I hear your concerns, and I experience the same concerns. And I don't know if that's an individual issue or because you're from a state, especially, a good council person is, we all love East Lansing. We love our neighborhood, but we love East Lansing, so.
Well, can I just finish? I was trying to finish. If we just voted against enlarging, previously there was a ward proposal that failed, I'm gonna venture that there might not be support for that. Not to say that, I said I was open.
I totally agree that
I'm
there
just
might
curious
not be
what everybody
support.
else-
I'd love to put it out there, but what I also heard Mark say, and I think behind the vote for expanding the council, there was a lot of awkward issues around it. So the ward didn't look good. I wouldn't have voted for that. So, and maybe it was required because the student population is much larger than us, so there's no
So what
way we could do wards.
Where I was
like
going
we
was,
also do.
if you or anyone else is interested in a ward proposal, what are the details?
Yeah,
And
I hear
then
that.
does this body think we should suggest council?
Phase one, but the next 10 years, when we meet through this again, I might be perfect.
Jill, that was the point I was gonna make. I don't feel comfortable making a thought on this unless we know how many there are.
Yeah, what it
I
would
mean,
look
if there's
like,
8 of them, I have a different opinion if there's 5.
or or even if there can only be two and they have to be right up
What are we
between the
dividing? What
university.
is our denominator
Yeah,
to come up with? So I think maybe we just
move on.
come
and-
back
Yeah.
after we talk about the number of members.
Is
That's my
everyone agreement?
thought.
with that? All right, so there's no changes really to the same as suggesting. My only thought on this chapter is nowhere does it say, and Tony, you should help with this too. Nowhere does it say that it has to be put someplace where somebody can see what the boundaries are and what precincts are. We have them on the website, but it doesn't say it's a requirement. It doesn't say, does it make sense at some point that we put something in here that's available? In the olden days, it would say there has to be at the library in City Hall, has to be a paper copy of that. Yeah. But does it make sense in this generation that we have to have something that people can have access? Where do they have access to in the charter, or do we just do that as part of our city?
Yeah, so it could be done that way, and it could be done on a section by section basis, like 1.1, or you could look at an overall obligation for certain publication to say if there are any documents required to be kept by a body or the clerk's office or whomever it might be, or made available to the public. One method or means that they must be provided through is the city's website, for example.
I think the clerk has requirements for notification of any changes.
We certainly, well,
Yes,
yeah.
for precincts, but I'm talking about if we didn't have this map of the precincts, how would you know where to get it? Go to Ingham County website, you can go to
the
Ingham
state.
County and
Yeah,
stuff.
the city,
But
so you call the city and. the
how
city,
do you know
yeah,
where the
yeah.
new boundaries of the city are? I
Yeah.
mean, if you just look in the northern map that we have, you see that along Chandler, there's a lot of properties that aren't part of the city. And so someone assumes they have an East Lansing address, that they're part of the city. How do you know that this charter doesn't apply to you because you really don't live in the city?
Could it be printed in the dialogue or something every now
Yeah,
and then?
and so what he's saying is that maybe we just have that in the miscellaneous, that any documents in the charter that are referred to will be located at, on the city website so that people know where to look. I mean,
Yeah, it's the difference between a policy and practice.
Yeah.
Mark,
Oh,
That's all. Okay, I think your suggestion could be handled pretty easily, defer to Tony, but if you added at the end of 1.4, something like, and a map of the election precincts shall be posted in all city-owned buildings when adopted, you would have at least the map available to people to just see without going on the website or anything.
in all city buildings, the
All city
aquatic
buildings.
center, the
Yeah.
library, the
I mean, we also vote in here, so it's very helpful. People to see that.
I think that's a good idea. I almost wonder though if it's more appropriate that be an ordinance change as opposed to something that would have to be enshrined in the city's governing document. So I mean, I think it's a great idea and we've communicated that to Mark. And I wonder if that's something that council itself, if council agrees it's a good idea, it would be much less onerous to go about it that way than to put it on the ballot.
Right.
When it seems like it's more of a policy initiative than a governing initiative.
And maybe we could find out what the clerk's requirements are around this, so maybe it's already covered in the clerk's requirements for notifying and posting.
Well, we have an election committee that meets, approves the precincts. I think it's 3 people, it's Tony, the mayor, and the clerk.
Correct.
And, once that happens, then we get a resolution and, go forward with it.
And the
So,
clerk takes actions to make that public.
right.
That's what I'm saying, so maybe
Sure.
there's,
Yeah,
Yeah,
so you're right.
there's a state law
It could be
mechanism.
easily done in an ordinance by just adding that requirement that once we approve it, then it's posted at all city buildings.
all right, so seems like we can either handle this as a policy. We can either add it into an ordinance that these are posted. We'll put it on the whiteboard here for at the conclusion, what, maybe a recommendation for a policy or just that documents are out there. Is that okay? No changes to
But
chapter.
we could even just add and made it available to the public. And then the details of that be fleshed out by ordinance. So like we could say, shall comply with election precincts shall comply with provisions of state law and be made available to the public. You know what I'm saying? So if the concern is that they won't be made available to the public, like the public won't know how to confirm their voting precincts.
I had a thought here. So when I was reading some of the charter earlier, and a lot of these topics that we have in agenda, chapter 1, 2, 3, are going to be things that pop around in different chapters too. Yeah. So maybe, I don't think this is in here. Maybe it should be, but maybe there ought to just be a section about public notice, transparency, communications, access to documents. Some of that stuff is in the city code, like it says in the code. You can go and look at, rental license information, show up at the office and look at it, right? So some of that's dealt with by ordinance, but maybe somewhere in here, there ought to be just a general more broad, like what's the information, brought it to the public, and have it posted or website or whatever, just food for thought.
Yeah, and the overarching umbrella.
Yeah, I mean, one of the things we hear every election is transparency. And people sometimes get in the office and it's not exactly
what the
transparent as everybody
process is.
wants, but the charter is opportunity to mandate some level of transparency that dictates to the city officials like this, what you gotta do. So,
Okay, so I've got the wards, I've got the wards, the precincts, the boundaries. Those are all kinds of things that are public documents. So how about if we wait and kind of look at whether we want to put a section in there at the very end, put it under miscellaneous? Because there might be more things that come up along the way that we're doing that we want to add to that, and we'll just use that as a topic towards the end. Is that all right? Everybody? Okay. Well, that takes care of 2 ballot questions, minus 2 ballot questions from the previous time. Out of the many, was it 67 or something like that? I'm sure we'll have our own, but, okay, chapter 2, general municipal powers. Okay, I'll put my glasses here. So I put this thing on.
Diane, sorry, you made that made me think too. It's a good point that like, however we end up with this, I think it's better if we can shorten the amount of, like, if we need to put something, let's put a question, just put a question first, but to the extent that list can be shorter and those sections contain all that I actually want, it's probably better, again, like splitting stuff into 2 elections and stuff, that just seems like a lot. That's what has to be done. But if we can not make the change of section, then include 3 changes in another section, that's probably a better strategy, I would think.
All right, so chapter 2, there was only 1 ballot question for chapter 2 previously, and that was that the charter be amended to have all the powers, privileges, and immunities that were possessed by a city incorporated under the Home Rule Act without needing to enumerate such powers. And so that's what they put in here. And previously, they had described the registration of electors for said election in this, the giving of notice of registration, the giving of notice of election. That was all a part of that ballot, part of that chapter. Now they just simplified it and said it's according to the home rule of city, and that changes. Then we have to change this, but they're changing it. If they change the date, if the home rules changes their date for amendments, do we have to change our charter then? If it's amended the main home rule city article?
No, I think they generally are presumed to refer to them as amended, so I think it'll automatically living in that sense.
Okay, so this was, I know Pam had some comments on this, and so did Jeff, and they were all under 2.2, exercise of powers. And it was talking about just the last line, discriminate against any person on the basis of marital or family status. And anybody else have some other things? I'll let you guys talk about. Anybody else had any concerns on any of this before I go to Canada?
And just,
Okay.
but just before we get into this, I know there was some talk about the potential addition of 2.3. I want to make sure, so under, under Michigan election law, there's what's called like a 60-day blackout period for the use of public funds by a public body or persons acting for a public body to discuss anything regarding those initiatives. So to the extent there's any discussion, it'll need to be at our next meeting after the election.
My only concern was, about this section, like this, 2.1, just references like two of the state statutes, like PA 279 of 1909 and PA 215 of 1895. I was just wondering, like, if, is the city like incorporated specifically under one of these, or the other, because there like are vague differences between these two pieces of the legislation from the state. Like one has stricter requirements, one, the Home Rule City Act gives the city like more leeway, so I was wondering, like, they claiming powers in both, or like, how is this interacting?
Yeah, that's a really good question. I was interested in the same thing. So Act 215 of 1895 is the fourth class city act. And my read of it at section 81.1C says that a city incorporated under the fourth rural city act shall have the powers of the Home Rule City Act until it has a charter adopted under Act 279 of 1909, which is the Home Rule City Act. So after we adopted our charter under the Home Rule City Act, we don't have authority under Act 215 of 1895. So I think that piece of it is vestigial. I don't think it references any actual powers the city has anymore.
Mark,
If I can, I just note that we were originally organized under the Fourth Rule City Act. That's the only reason.
Okay, yeah, so, yeah, I just suggest possibly removing that as we go forward.
okay, so I'm going to ask Jeff to go first with your comments about that, that section of 2.2.
Well, I just thought, so this section, general municipal powers, I read Pam's thing, and then I started thinking about it, and when I was referencing the Flint City Charter, it's like, I view the charter is like a constitution. Constitution outlines the powers that a government has, but it also typically outlines the sort of confines of that power, restrictions of that power as well. Like, you know, the U.S. Constitution allows officers to use that, but also prohibits certain things. So this just says this is just about powers. You know, the sort of declaration of rights that like Flint has, which is, sorry, I don't have to run it down, but I think that comes to the preamble before the actual numbered section of the charter. And I just kind of thought, you know, maybe that if this were to be done, so it's like the first thing to the charter of Flint. Thank you. That maybe, you know, again, this is just broad thinking, not what to decide tonight, but sort of for discussion that maybe general municipal power should be its own chapter. Maybe a declaration should come before, which sort of defines those powers a little bit as well, or maybe there should be a combination chapter here of, you know, the powers of the city, but also describe how those powers are limited so they don't infringe upon rights of everybody in the city. That's sort of all I was thinking about, and then I just thought Pam made some comments. I wasn't sure what she meant, so I think she should stay.
But what I'm saying is, so discriminate against any person based on marital or family, I don't even know what family status is, but I would have expected to get protected classes.
Okay, so
That's
that's
it.
why I had the email to you. I thought Pam might be protected classes.
Yeah, that's a
Which is
question,
fine.
but yeah, that was, I just thought like, this is that where,
Well, and shouldn't that be in here anyway, right?
Yeah.
It's not.
yeah, that's the
So-
preamble, so that's what I was thinking,
Well-
like, that maybe is the preamble content, but why? What, and do we know what the origin of the family status, what's that? Are they running divorcees out on a wheel at this point? Is
I can't remember, you know, whether this precedes, it sounds like we didn't make any change to 2.2.
It was, not
this?
just.
2.2.
I thought it was sort of a
No, nothing in 2.2.
Gay rights issue.
Here's the, sort of the background during that period. There was, in 1993 or 1994, there was an attempt by the city to make sure that non-traditional living arrangements were covered by insurance in the city. There was a group in the city who then fought against that and sued the city, and then circulated petitions to separate a whole bunch of areas from the city back into the township. And so we wanted to make sure that family status would be something that we would protect. And shortly thereafter, in 1997, so the year this was adopted, we adopted the more general family definition into chapter 50 of the zoning code that includes domestic partnerships, so that we wouldn't have this argument ever again. And so family, because there's such a broad definition of family within this community, it protects anybody who comes within the nature of that definition. So that's how it stayed in there, if it stayed, and how it was put in there. It wasn't, it could have been part of an amendment that took place before the 97 or the 97 votes. But that was what happened in the city at that point.
So do you recall how the family is defined?
Yeah, boy, I do actually kind of, I'm not gonna say I'm showing this correctly, but one unrelated, two unrelated, unrelated, two unrelated, and one person. The traditional family that is defined all the way through nieces and nephews, and brothers, sisters, cousins, everything that you can imagine in terms of that. All those are defined as family within the ordinance. There's like, I think, 3 or 4 subsections which also define domestic partnership and other aspects of family life within the community. So when you see a provision that says say 2 unrelated or a family for a license, family can be a whole bunch of people. So it's a broad definition. I don't know. I don't know of any community that has a broader definition of family.
What chapter was that again? I'm sorry.
What's that?
What chapter is it?
Chapter 50.
50.
And I can't remember the exact site. Maybe Tony has it there, but it's in the zone.
It's in 272, but I'll have to check.
Yeah, I think you're right. And we're about to incorporate, like actually place it in the amendments that we're proposing to the rental housing code, so you don't have to go to some other place to see what the definition.
So does the group feel like this last line needs to be changed? I just want to have a gut check here.
Well, I guess I would suggest it either be removed or be altered, because when I read this, especially in the first, the municipal powers definition, but you could discriminate against a lot of other people based on a lot of other things, like this seems to be the only protected class.
On that point, I mean, the city of East Lansing and its officers, because of the US Constitution and the Bill of Rights, cannot discriminate on the basis of race, religion, gender.
But why call this out?
This is called out, I imagine, because this is something above and beyond what's traditionally seen as a protected class under the US Supreme Court's jurisprudence.
Germany, blowing my mind.
So I imagine that's the answer. Marital and family status is something that's not typically protected.
But
One
what
other
answer?
thing that's often referenced that's also not protected is economic status is not a protected class. And that's something that I don't know what the ramifications of it would be beyond this code. I think that's something that we might want to consider as well, that city and its officers can't discriminate on the basis of economic status.
I think that's really important.
Yeah, and I think that your point that the other
It's already done,
protections
right?
are covered in somewhere else, I fully accept that.
So does it make sense to in this thing, to reference what's protected underneath because like we reference a lot of other codes or laws. Can we reference that in addition to marital, family status and economic status because they aren't protected classes?
Right. Classes protected under federal or state law, and I think that would be an option.
I was.
I'd support that too.
Why
Looking
wouldn't
around.
we just put a
And I,
period under after person, just be, cannot discriminate against any person, period.
Oh,
I think-
Got a
I
listing.
think-
Got a listing.
I think
Sid Master.
an issue there is that it's extreme, you know, then you get into the question of what does it mean to discriminate against a person? If,
Any individual.
I mean, right, you want to do it, I think, based on classes because I'm just thinking out loud here, I'm fully, but the reason it's done typically based on classes is because there's, there are legal requirements, you can't, you know, the city already cannot pass what's called a bill of attainder, right? 'Cause that's also against the US Constitution that prohibits, or that singles out a specific person for a specific, prohibition or specific, or something like that. But I think it's better to be specific about what you can't discriminate against people for. Because by doing that, you virtue signaling is such a bad term, but you say this is what you can't do. You know, it says it says this is what the people of the city believe in, this is what the people of the city want done. And just saying you can't discriminate against any person doesn't do that work, I don't think, as opposed to saying on the basis of specific classes
Okay.
or characteristics.
Yeah.
And where does student status come in this? Because we had that specifically that the student status was a non-discriminatory class.
Right, we
That
have
wouldn't be in your federal, right?
It is not.
Yeah, can you copy the language from the city ordinances of all the things that
Yeah.
is protected, and then
I
we
was
look
just trying to
at
look.
whether we expand that, some of these other things.
Okay, does that make sense? And you'll provide that piece and then can you possibly draft something that might address what we're talking about here then for next
Absolutely.
time? Does
Is
that
the
sound good?
Is the consensus to make this like fairly broad? Protecting from that.
Yeah, I like.
So many direction.
It's
And we discussed that it's going to be in addition to what the protections required under federal and state law, which probably should be here already.
Okay, anything else? And we possibly have one ballot proposal. After 3. Okay, now 3, I'm gonna go to chapter 3. I think this is fun. This is really good discussion. I like how we're feeling free to do this, work on this. And we might have to come back to some of this stuff too, so feel free if something comes up later and you want to look back, just ask it, put it on the agenda. So there were 9 ballot proposals on chapter 3. So there's 13 sections here. So let's just start off with the first one, or just, 13 sections. Elected officers of the city shall be 5 council members, all of whom shall be elected by the city at large. So do we leave that for now? Do we want to have more discussion? Jeff has pointed out that the voters rejected that just recently. Do we?
expansion of it.
Is there support to do anything with that right now?
Probably because they rejected it, could you bring something up this week?
So if a ballot initiative under the Home Rule City Act is rejected, there's a period of 2 years. So it would be permissible by the time it went through the process.
Okay.
I didn't see anyone moving for that. Okay, 3.2, eligibility for office in city. So here, just a question that's going to come up over and over again. He or she is in there. So we want to have inclusive language. That would have to be changed by ballot proposal. So do we want to just right off the bat say they?
They are.
What if you said first or second?
Then you have to define.
Say a person.
So no person shall be eligible for effective office.
Unless that
Office
person
of the
is
city,
a
unless
resident.
That person is a resident.
How, they are all persons.
Yeah, so I said person.
I wonder instead of, what Jeff was talking about earlier, having fewer proposals rather than more, we just would.
We're
get
gonna
at the end
change, yeah.
that when he or she's referenced, it's to include all genders
Well, and I don't,
or something.
what I think we can do is that we could have a proposal to have a question to amend the charter to say anywhere there is a gender related reference, it should be made gender neutral. I think that there may be more conversation on gender neutral because some moved to he or she maybe 10 years ago, and now that's being moved away from.
Right. We have
but-
she, a buffer.
I like what you said as a person, because using person.
Yeah.
Of that.
Yeah, but you want to be careful. You don't want to do he, she, and then say, but we're really meaning this. You get
Yeah.
interference.
Sure, understood.
That's an easy edit. It's an easy edit.
So if he can do that throughout the thing, when anytime there's he or she is would be placed with person, then he's gonna prepare that one.
Now, I was surprised there wasn't a duration. So has to have resided within the city for a week before they registered. Like, like how does that,
So there is some legal authority on that. There have been some charters that have required 2+ years, which the courts have found to be excessive, but 1 year has been found repeatedly to be enforceable.
So do we have that in ordinance format?
We can have.
so right now we just say you have to, this would be the line and you just have to be a resident, but with
Meet for a
no.
week and we can run.
Isn't there timing of getting your name on a ballot?
Yeah, I mean,
Would
it's
require you to
really,
be before that process.
So you have to submit your application to run. And
That's
that's
roughly August 15th that you have to have stuff in mid-August.
yeah, so most charters, if they did have that provision, it would say for a year, you must be a resident for a year prior to the filing date. Or that, or whatever, yeah, exactly.
And registering to vote does a lot of that work too, because of the paperwork you would need to do in order to register to vote, be domiciled, to do all of that. So I think any concerns we have there about the length of time are already kind of baked in.
Wait, you assume everyone running is registered to vote?
Well, that's what the charter requires.
But I guess the question is, do the people know that?
Oh, and be registered to vote in the city, but don't we have same day registration?
But if we're, I was talking,
About
Dr. Martinez was talking about residency. And in order to register to vote, you have to have certain documentation that shows you actually are residents, and that takes time to get to your actual residence. So I don't think we have a concern about someone
Well, and I
living
don't-
here for 2 days and then running for council.
Right. Mark, you have a thought on that?
Well, I do recall, I can't remember the name of the case, but the limitation on registration of students was in place for a lengthy period of time. That was blown out in court. And, we have constitutional provisions that have been adopted recently that allow same-day registration, early registration. There is, we're really more subject to, in a federal election, federal law, in a state election, whatever the state has established with regard to it. Maybe there's some case law that indicates that we could say, you have to live here a year in order to run for city council. But I think, we haven't gone in that direction. We really used that prohibition for, essentially you couldn't become a resident of the city if you were a student at a university, to restrict student access to politics in the community, and we rejected that by adding that status to our civil rights ordinance. And I think going back on that, there would be, I think, a discrimination issue that maybe we don't want to have, experience, yeah.
And I think that's a good point that Mark brings up when we reference back to the conversation about wards and one being potentially student area only.
Two.
Yeah, or two, right. Students very routinely have not lived here for a year before the filing date. And
That's,
so,
that's,
yes, so that's a really good point.
all right, because the student population, that makes sense that maybe a year is not required, because if we have almost a kid, if we have a young person that one student that wants to run for city council, they should be able to do that.
So 3.1 and 3.2, the only changes are overall one that we want to have is person replacing he or she. I said I would do this. They eliminated in 97 the municipal judge as an elected city officer, and they, because that's replaced by state law, which declares who's going to be there, and they just had it was 5 for 4 years. The 3.3, the term of office of council members shall commence on and date from the Tuesday following the regular city election. This is a problem, and it has been a problem at different times, because sometimes they don't canvass, or the county doesn't have the election certified by that Tuesday following the election. And so it would make more sense at some point that we have this in there, that after they used canvas, but is that the right word, that the county canvas? Is that the word?
Certified?
I use certified, but I found later in here under 3.7, it's canvas. So this goes with the same thing. Until the last sentence, until the approval of the canvas of the election, with which he or she.
So that's the action by the committee. Yeah, and that, we tried to, we tried to put this change to 3.3 on the ballot last year as well. I don't believe it made it on. There was a timing issue with the approval or the projection of the Secretary of State. As we've talked about, if the Secretary of State rejects, there's a time frame in which the city council can override. The Secretary of State rejected it the day of the deadline. And so we didn't have any opportunity to set a meeting to override her rejection.
So if we addressed it in 3.7 and just ended the term of a council member shall be 4 years, can we deal with it in 3.7 and not have to amend? But we still have to drop it on 3.3. We still have to put that on the ballot.
I think it's again 3.3.
So what about the idea that, there was that home rule where you try to be as independent as possible and save your autonomy? What if we don't wait for the certification? Because our elected people, will we have any, so we count our ballots, do we know what we think we've seen before the certification, or do we not really know? You know what I'm saying? So if
What
we,
we think.
yeah, so we have.
Doesn't mean anything until.
Right, but except that if there is a holdup in the counting, if that becomes royal illegal and the election is in suspension, might we not want to move ahead with ourselves separate from whatever relay, if we could know what our numbers look, you know what I'm saying? Just saying, like, is there a way that we could keep out of that fray? And then if something's changed, then, you know what I'm saying?
The issue, so the reason 3.7 is in that just as until successors are properly elected, you're still a valid member, is because that shows that anytime, say, it happens, election happens in November 5th, December 5th, we are still waiting, or whatever the reason might be. This shows that those that were previously elected are still valid members, so that when they sit at a council meeting, they can have a vote.
Even if it's beyond the 4 years?
Correct.
Oh,
And
okay, so
so,
that covers that.
but because the alternative is to say, well, we think these guys are the right ones.
Yeah,
so
that's why
let's
I
put them
think
in.
that would be messy.
And it was wrong, then any of the votes that they participated in, their question could be, or their vote could be invalidated.
So we could have an operating council in that scenario
That's
where the
exactly what
certification is
3.7
delayed.
does.
Right
Yeah.
on, all right, good.
Wasn't there some concern about a lame duck? People being left over that are out and then they could get together and pass legislation that. There was some sort of
Well,
discussion.
somebody, they wanted to have like everybody, like the county and everybody goes in January and that's when they take office in the surrounding communities. But we don't. And that eliminates that lame duck session from doing that. And I know one year I had to chair a council meeting because we didn't have the canvas and we just had nobody show up except for me. And I said, there's no quorum, so we can't meet to do anything. Because there was an agenda, because you have somebody that wants their building approved. And you said, this is when it's gonna be, and, you're trying to follow a process to help the people that are applying. But then we didn't get the canvas done. And so you wanna do it the right way where we can't have a meeting. I don't have a quorum. The thing hasn't been, because the people that were voted out didn't want to show up anyway. And it's very hard. There's only one time have I seen someone show up after they were voted out in that interim. And hats off to them for doing that. But
There's no concern with that then.
Yeah, I'd say that the argument against the ballot proposal last time that would move the swearing in date was basically the idea of lame duck. And I'll give you my own little lame duck story, even though it takes up time and you can use it on something else. But when I was elected in 2006, it was in a special election and a regular election. So I took Gretchen's place because she went to the Senate in a special election. And I was sworn in immediately. And so I sat through my first lame duck as a freshman on the floor. We passed 260 bills because Republicans were losing. They had lost control of the House in that election. And so the danger of a lame duck period is huge, actually. And it's baked into the federal system and the state system, but we don't really get it here. We have a better system, which is you get elected, you get sworn in, go to work. That's it.
I was making sure we were gonna somehow encourage lame duck system, because it's not exactly what you're saying there. All right.
Fine. We did have the latest certification.
so it sounds like you need to write the language in there to cover the canvas in this.
Yeah,
one.
so what we could, I just want to make sure we have everyone has an understanding. So the terms of office currently says shall commence on the date from Tuesday following the regular city election at which they're elected. We now know because of the allowance for overseas ballots to be postmarked by election date, we typically will not have the canvass completed by that Tuesday. So the extension, I think there are two options in the conversation. One is that a lot of communities have followed the state, creating a lame duck by saying they are sworn in on the first Tuesday of the year subsequent to the election. The other one that Chair was referencing is tying it to the election date. So you would say you're sworn in the Tuesday after the canvass is completed, which means whenever that happens, they come in not less than a week later.
That's pretty good idea.
Everybody okay with
Is
that?
that
I think I'm okay with it. Just for those of us who aren't intimately familiar with the election process, what are the steps from election day to final certification of the results? If you know.
I wish she was here. I wish the clerk was here.
Yeah.
And we do a local certification, and the clerk has the sole authority to certify at the local level. She then transmits them to the county reviews them, and the Board of Canvassers then certifies her determinations, essentially confirming them. That is the final step to ensure that our city votes are in final determination, and at that point, they'd be subject, to any adjudication if there were.
So the county is the final step beyond judicial review.
That's correct.
And the meetings are scheduled ahead of time for city council. A year in advance, you have to set them up. And that's always sort of in the back of your mind, depending on the calendar when that election is, because the city council used to be the second and fourth. Now it kind of varies a little bit. So the first Tuesday was this, then you had 1 week later. We found that that wasn't always true. So if you use the language, the Tuesday following the canvas, then when they set the dates ahead of time, it can be the second week or it can be the third week, just whenever that is. And if it's not done, they can move that city council meeting to the third week if it's not done. By just announcing that we're putting it on City Hall 18 hours in advance, right?
Yeah, and I think that's, the council agenda that was adopted for this year took that into consideration, the fact that it was an election year. So the only meeting actually in November is the 19th, which gives 2 weeks after the election.
But just to be clear, it's the canvas by the county.
Right.
That's closed.
So then, so let's see. Just information for you on 3.2, I didn't tell you this, that they amended it in 97 because they took out that if a person was in default to the city or school district, county or municipal corporation, that they couldn't run. So if they owed back taxes, assessments on their property, so that was removed and it was just eliminated from there. And then we're getting to 3.4 now. And so the old one and 3.4 was any city office can become vacant when the occurrence of one or more of the following events occur before the expiration of their term. One is any reason specified by city law. So we still have that in there. If the officer of the city shall be absent himself continuously from the city for more than 60 days without permission of the council. C, in the case of the mayor and members of council, where the officer shall miss 4 consecutive regular meetings, or 25% of such absences shall be excused by council, and the reason therefore entered in the proceedings of council that was there before. And if the officer shall be convicted of any constitution misconduct, any act constituting misconduct in office under the provisions of this charter. So they changed that to what you have here under 3.4 to clarify it. And that's really what they wanted to do, what that meant. So I am going to ask just a little role play here because I just wonder where you all are on this. So if you take 3.4B and you said, without being, if a council member misses 4 consecutive regular meetings of the council, then you just go to the end, without being excused by council, what would you expect an excused council member? They're excusing them all the time now. You're not there, they're excused. Is that okay to just like, I went out of town this week just because I had a chance to have some fun. Would you want that to be excused? I have chemotherapy for the next 6 months. I'd like to be excused from council if I can't make it. What kinds of excuses would you see as a citizen to be valid that you'd want our council members to excuse? Because that's not defined anywhere in here. What's a good excuse? Right now, they're excusing everyone to meet that. But we've had some different cases. We've had some people very sick. What if somebody has a sabbatical and they're going to be gone for 6 months and they want to take it? Should they stay on council or should they? Because that doesn't meet this criteria. And I just like to have your thoughts because I think that's important if we just keep this language the same. If you feel it's okay or you feel that should be defined.
I think that's a fantastic, I'm so glad you brought
Great
that up.
question,
Yeah, and I was frontline supervisor for many years, and it was not my business to validate your reason for the need of time off. It was my job to make sure the work got done. So do should we care if it's, is there work to be done by a council person that can go undone for 6 months, whatever the reason of the absence? You know what I'm saying? So that's,
You have five, we agreed, 5 council members.
which is not very big.
And if you have 4,
Can't,
3 have to be there for a quorum, and 2 votes will give you,
what do you think, Mark? As a person that's lived it.
Okay, well, I've been granting excuses for many years. So it's really the discretion of the council. And when you have 5 people working together, every once in a while, somebody can't be there. And they've been excused, and this provision indicates basically that if you're gone for, that could be a month and a half of missing any of the business that the council needs to get done without excuse. So really, I don't know that it has ever been utilized. I don't think any council member has become removed from the council because of this. And I think the council tends to use discretion. If you've got a member who doesn't seem to be doing the job, I can't think of that ever happening on any council I was in. And so I'm not thinking it ever will. But if you had one on other boards and commissions that I've been on, you counsel the person. You meet with them, say, what's going on? Why aren't you showing up? And, you might see because almost every board and commission has a similar type of requirement to grant excuses. And what I found is that usually the person then starts to do their job. This is a failure to be excused is a tremendous incentive to do the work, because what could be more embarrassing than getting elected to a city council, this city council in particular, and then being removed by operational law because you missed a bunch of meetings. So I think it's fine the way it is. I will say that in 2018, I had a leave of absence, which the council granted. And it was, I had somebody at the door the following year say, you went on vacations, it was a kind of a vacation, although my wife and I hiked across northern Spain. So it was kind of a lot of work too. Sounds like a vacation. But but they were kind enough to do that. I really didn't miss 4 meetings. But I wanted to be sure that the public knew what I was doing and the council was okay.
Did either of you ever have times on council where you didn't excuse someone's absence?
Yeah, if somebody just suddenly, couldn't be there that night, I might have forgotten to, make a motion to excuse or something, but generally speaking, if people miss a meeting, they miss 1 meeting, then they're back in business. I really don't have any memory of any council member who failed to show up with any regularity whatsoever. I don't know, maybe.
well, his
Diana?
own fairness, he didn't show up when he was very sick and he was still on council. He didn't resign. He stayed on council. And they would excuse him because they weren't sure. I don't think they were writing him off that he was gonna die. Then, you had Ruth, who was gonna take a class for a semester and that was on the same night as the city council. And they didn't excuse her, they changed the night, the meeting schedule to adapt to that person. Then you had, somebody, George had COVID, and so, you excuse somebody for that. But if you have like a work, there's many times when I was on council that I might have to go for work out of state. I didn't get excused. We didn't give excuses for those one-time things. We gave excuses if you were in the hospital or you were sick. Because the one-time things can add up and you have to be, to me, we always felt you had to be committed. But you guys are doing one-time things all the time to protect yourself against everyone.
But my concern is, and I think I heard it with, if you're an unbeloved member of council, you won't get excused. So I don't want, it wasn't my babysitter or you want to go to the bar and party, not my business to judge those two things. They're both your business. You know, I couldn't say, oh, you're taking care of a kid, of course you'll get this time off. No, here's how we delegate time off. It doesn't, you're reasoning. No, and I think that the excuse is you didn't just no show. You contacted the council, you notified that you were gonna be absent. This kind of addresses the person that just kind of disappears. It doesn't bother to communicate and is clearly disengaged and.
Yeah, I think most of us agree that there have to be reasonable, substantive reasons for not showing up. The problem is language. And coming up with language that would really cover something like that.
Stop people from lying to you. Because they'll come up with a better story to
You know,
get out of it. So
what I
that's-
said is difficult to define.
Reasonable. Yeah.
Right, what's reasonable? Whatever he says.
Done.
My thought is that the check is already here by requiring council to excuse it. The council ultimately is responsible to the people by the next, through the next election. So if people feel that there's an absent council member or that council itself is being too lax on an absent council member, that might be an issue in a future election. I don't think that our governing, I don't think that that the governing charter of the city should lay out what is and what isn't allowed, when we can leave it to the discretion of the people that citizens have trusted to govern the city itself and to govern each other.
Right, not vote for them again if they. appear to
Exactly.
Miss a bunch of votes.
Exactly.
And the only thing I've really seen, the reality is we don't pay a large amount of money. If people are gonna go through the agony of getting elected to be paid on essentially nothing, they want to show up. In other communities, I have seen if a leadership board or council has things like family health insurance that's offered to the members or substantial pay, like it's a part-time position, that gives incentive to, I'm gonna run this job and do the least I want, and that's the only times I've really seen that come up.
Yeah, I'm sure that, our hourly pay has gone up substantially,
Went
but
$3.
I think we're still way below minimum,
They did remove the last time that the reason would be that they were excused by council, the reason that entered into the proceedings of council. They took that away. Yeah,
My child's in the hospital,
Yeah.
Yeah.
Mark is touching in Spain.
Yeah.
Well, that was the leave of that.
all right, well, just a good conversation to have, so everybody understands that that's okay. That's standing up okay, and then they talked about the misconduct in office. Oh, no, I'm on 3 point. They didn't do anything more on that, except they more defined what whether it was a misdemeanor and what kind of act it was, so they put more things into there. The resignation one on 3.5 and 3.7, says they were both amended on one ballot question, and that was when the resignation was effective. And effective in the date of the resignation, immediately effective if no date is specified. And so, that's what we have there. Before it was,
Can I bring up
sure,
an example? So the
Sure.
Saginaw County ran into a situation where a commissioner moved. And when you move, the Secretary of State automatically changes your address, even though she hadn't physically relocated. Her address now showed a new house, which invalidated her position on the commission, but she sat through 2 meetings because she was still residing in the community, even though the Secretary of State's changed, and so they had to go back and redo the decisions that occurred because of that. Created an automatic vacancy. Yes. Yeah.
and I did have someone who resigned, and it was effective that date, and that really starts the clock going, that you have to replace them.
Is In that circumstance, that was one thing I was gonna bring up. The 30 days is often. Was that an issue to get someone in a seat within 30 days to publish it and interview and whatever?
We did it. I mean, everyone who's on council is committed to getting in there and getting it done. And there seems like there's always somebody willing to apply to be on council for that, as somebody did apply when there was a vacancy once, Mark's vacancy.
Well, let me just mention that Diane took my place on council and I had to resign to take my seat at the legislature.
But there was a process of being interviewed, and there's been two ways that people have done it. One is that you submit your name if you're interested, the council set up interviews, ask the same questions. I can't remember if they did send out the questions in advance, and so everyone had the same questions. And then the council met the next week and made that decision. One time they met after all the interviews that same day and made the decision. But another time was when Aaron Stevens resigned because he moved to go to graduate school. They asked for applicants and Shanna Drahan applied, and she had been on the council previously, and it was such a short time that they didn't interview. They just asked her if she would come back to council for that short period of time before the election. She did. It wasn't a year, it wasn't a huge amount. And if I remember correctly, Mark resigned in the summer of 2006. And the election was 2007, so it was over a year. But when it was that short time, they looked at the applicants and they said, she's fresh, she knows all the stuff. And what they were dealing with at the time was the income tax and to bring someone up to date and stuff like that. So if I remember, that's the issue at the time.
Yeah, we also did that when Wally Jewell resigned. He was elected to the county commission and he resigned from city council. We appointed, forgetting Frank's last name, but he was head of ASMSU to fill that short time that Wally was going to be off. So I think there's been a variety of appointments there. I think the question here for me would be, is the 30 days long enough in today's era for us to make a really studied decision on who should replace, and should it be within 30 days? Do we really need to make sure that that seat is filled within 30 days? So those are just questions. I don't have an answer for you.
But it hasn't been a problem.
No, and it lights a fire. I would say because of all those people that are coming with their applications, you don't want two people making that when you have four and your quorum is three because somebody is out. I mean, every time you narrow that down, it makes your commitment to be a little laissez-faire if you don't have pressure on you, because nobody wants to be there with three council members and take a split vote. That doesn't feel right to the people there.
Yeah, they would conduct business too, so it would take longer. Those problems.
Yeah. And especially depending on the time of year too, sometimes it just depends. When you're doing a lot of things are coming up so that they can build in the summer, you really delay somebody, and that's income to the city, but it also is their livelihood. So I don't know that anyone has never asked for not everyone's gotten it done in 30 days, and we've got lots of examples.
I'll just add one thing. You asked about the where the ballot proposal that was adopted last year sits. Part of it sits right here, and so the end of 3.6 reads for better see if I can read this, or call for a special election to fill the vacancy. That was added by that ballot proposal. So I know it doesn't show up here, but that is actually part of this provision. And that would be something for you to discuss and talk about. So it gives an option to the city council to do it differently.
I'm not following.
Okay, at the very end of 3.6, this language was added by the voters last fall. Or call for a special election to fill the vacancy. So the council can fill within 30 days, or it can call for a special election under the change those.
I like that. I think that's kind of nice, good option. It's tough for the council to make a decision. We'll let the voters decide, you know?
Never cracked the law.
We'll wash our hands of it.
And that he just whispered to me, that was the ranked choice.
Yeah, that was
Not
part of the
that
ranked
it
choice.
was a separate one. And I, okay,
So the only thing I can bring back up is when it says 30 days after the vacancy occurs, should there be a notification to council for that 30-day clock to start? I mean, because you could have a vacancy that occurred, you find out you've only got 10 days left because notification.
Don't they have to?
but right, they have to tell each, everybody got a letter under 3.5 immediately.
Understood, but if they relocate and they don't realize that their address made them invalid,
Or if it makes it a
Retroactive.
misdemeanor and it's not made
Right.
known, because it's done by operation of law, it's not
Right.
done just by letter of resignation.
right, and that's my
Oh.
point.
And the other thing that isn't addressed in here is if they pass away. I think that's gotta be listed somewhere.
It's probably under
As
3.4.
another option.
I didn't know if there's a statutory side for state law reasons, there's a vacancy.
Yeah,
Maybe that.
that's one that.
I want to talk about the section, I had a bunch of things about 3.4. Are we going over
I'm
generally?
just, I'm going over by what was changed
Okay, yeah,
before, and I'll just say, the other one under, that, 3.8, about the compensation, it also eliminated the ability for council to determine compensation for agents and contractors after the service has been rendered in the contract. They, council before in the charter had the right to do that. Now it's the city manager. And so they eliminated that. And then, they, 3.9, 10, and 11 are covered by the, you wondered why they're gone, they're covered by now covered by the Michigan Constitution of 1963, so that they were no longer necessary. And, and then ballot question 12 related to 3.12 about getting your stuff back, the city's stuff back. That included papers, books, lots of different things that were there, which is the truth now. It's your phone, your computer. I think that's pretty much it, right? And your parking pass.
Yeah, and the now that should be
That's
retained,
valuable.
that should be allowed.
Just like retiring from the university. So you're saying that the oath of office bond, the surety bond, and the liability bond are all state, they're identifying the state
And the
regulations that are now, this is under.
Yeah, there's a standard there about. Relative.
And then also, the final thing in section 313 was about conflict of interest. And so then again, they went under the state law regarding contracts contained in 1968 Public Act 317 supersedes all that. So that was changed to reflect that. So
How often does that come up when you guys are council? The pecuniary interest that someone, you have to wait for somebody like.
I don't remember it ever. I would guess that maybe if you, I can't remember whether we ever had like a landlord or maybe a developer on the council, but that's who it would likely, with that's where the issue might come.
Vic Loomis was
yeah.
on one of the buildings. He didn't feel like he had that, and he itemized why, because of how he was using the building. I know I excused myself twice. Well, I asked to be excused. One was because I belonged to a church, and the church property was up for how they used the church property, and because you're a member, you really have a fiduciary responsibility, so I don't know myself for that. But the other is I was on Blue Cross Blue Shield, and as a board member, and they were, they had a property at the end of Coolidge, and they were trying to sell it. And so every time they were meeting with staff and stuff, they'd want to have a council member there, and I had to step back and say, I can't be involved with both sides. So that was the problem.
And I once, I made a motion to recuse myself because we were involved with awarding money to an organization that I was on the board of directors. And there was a vote and they rejected my request. So I said,
Recuse yourself. At least you got a public, though, that's.
yeah, I mean, it was in public.
And looking at you, who said almost everybody has a conflict of interest because if it's something in their neighborhood, that might affect.
Yeah, absolutely. I mean, so that's why I think it's more limited in Act 317 if everyone has to explain every potential conflict of interest, just like you said, like, oh, I have health plus insurance and small that or whatever. I mean, there's a lot that you have to look at as rational, like something that it would be hard to look over, like, you know, someone was going to sell their personal property, was pointing at Fort Brookover's law office over there. If for some reason he was selling it and the city was buying it, he would clearly have to recuse himself, right? But there's a lot in that grading.
So they covered, we're gonna do next, but that's all they covered in the changes. And so what we have here is what we have. So go ahead.
So just to be clear, the waiver must be approved by a floor of the five.
I think 3 of the other 4, I think is how it reads. It's, unless I'm reading it wrong, 2/3.
Majority of the remainder.
Yeah, 2/3 of the remaining members. So it's 3 of the 4.
Nathan Triplett was buying a house in the neighborhood that the city was developing, so he always recused himself from any discussion. So those are real examples. Okay, Jeff, you have a lot.
Well, yeah, I mean, Jonathan sparked it last time, the more I got thinking about this, I mean, so one of you, it would be curious, what exactly, state law says there's vacancy. I can keep that. We went over the attendance thing, which I think kind of also covers some of these criminal issues, and if someone's in prison, not gonna get excused for missing meetings, right? Right, so, and they're not gonna make it, so they're being held out, but the more I thought about conviction of a felony, and even misconduct in office, which isn't defined, I mean, there's some of these examples, and it's also at the end of 3.13, you have pecuniary interest. But it's not defined, and I just, the more I'm thinking about it, okay, E makes sense, you're not a resident, they're after the state law, it's the state law, and I know about an oath, and I'll pay. That's an issue, the oath, I don't think.
No,
will
we're
change,
not.
but
It's not our own, it's a state oath.
C and D. I just kind of think big picture that the voters should decide whether someone's in office. And, I obviously could see like someone doing something in office, they should have done that. And, we don't want people committing crimes when they're in office, and all sorts of stuff, but I can think of all sorts of hypotheticals that could happen. And I don't know if some outside power should be able to remove somebody from office if we voted them in.
What if the outside power is the state?
Just giving you a hypothetical, so like, we'll use Councilmember Bennett, so I don't mean to be glib about offending anybody or anything, but, okay, so let's say you have a niece in Texas who, is raped, there's incest, and she's helped the mother needs to have an abortion, she can't have it. So Councilmember Meadows goes down to Texas to transport his niece here to Michigan. He's crossed state lines, and either the state of Texas or the federal government decides to prosecute him for a felony. Should he be removed from being our council member for something that's legal in the state of Michigan? It's one hypothetical. Some people may say, yeah, but other people say no. And even that, the fact that people could disagree on whether something should be a crime or not, makes me think, well, that shouldn't remove someone from office. You could be down on the Indiana border with your grandma in Michigan and visit a medical marijuana store to get something for her, and she starts having a heart attack. You drive over the border and take her to South Bend because he's a better doctor. And you get her there in time, thank God, and then you're in the lobby, and police officer says, you smell like marijuana. And he says, oh, shoot, I'm sorry, I was in Michigan, I didn't mean to cross the border, but my grandma's having a heart attack. He says, well, I don't care, you're in the state of Indiana. You've also crossed state lines, so it's also a federal crime, but we're gonna charge you with felony for intent to distribute, because it violates our laws, right? So I can think of these hypotheticals that maybe will not ever happen, but could, and I wouldn't have, say that our elected council members should remove it. We have the power of recall. It's in section 14.10. that follows state law. State law was changed during Rick Snyder, it made it harder to recall people. I doubt anyone's ever been recalled in Lansing that I know of. It's very rare it happens at all. It's difficult to do. If our section tracks state law, because we have 4-year council terms, you can't recall somebody in the first or last year of their term. So it's very narrow. You have to have 25% of the signatures in the last gubernatorial election, and have a certain amount of time to do those signatures. Very difficult to do. The section I said about Grand Rapids allows for 45 days, you get 45 days in the office, and after that, you can recall someone. I think they have a 25% vote. So it's similar to like the initiative and referendum sections we have, you could create a different standard for recall at different times, or you could make it easier to recall someone. Now, people who are on council probably feel like, hey, I don't want to get recalled every time someone made. So you want to make it tough enough so that it's not regularly used. But where I'm going with this is that there's mechanisms to remove somebody from office. There's different ways. The governor has the power to remove someone. So if someone commits something really heinous, we're all like, oh, that's horrible. You're probably either going to be in prison, and you would be kicked out for attendance policy. The governor could remove you, or we could recall you. So I would just think some of these potential provisions, particularly, I don't know what misconduct in office means, except, I guess, you can read those few things and say, yeah, you missed a lot of misdemeanors days in jail in Michigan. Wouldn't actually disqualify, but I just think it's too wishy-washy. I prefer to have the voters have the authority over it all.
Well, that's interesting because that was defined in 97. This is the section that they thought it was misconduct was too wishy-washy, so they put that in there.
I still think it is.
I guess, and I think that that's why I sent the piece from Omaha, the Omaha City Charter, where a public hearing. So it's not an automatic, but if the rest of council agrees that, you know what I mean, that maybe in your scenarios, the rest of council would say, no.
Hey, Mark.
I think that's another option is they have.
Right,
council-
they didn't recuse themselves, they probably, so that would keep the tenor of our community.
But then we have to come up with the whole standards of like, well, when can council decide?
Right, it's their appeal.
Yeah.
I agree generally with what Jeff just said about the ambiguity of felony. I mean, it's not ambiguous because it's defined in state law, but limiting it to felonies that you could argue clearly affect the confidence that the community might have in your future conduct. So if you're convicted of a felony for bribery, for instance, that would be something that I think we all agree on. Get rid of that guy.
Like a violation of public trust.
Right.
Not to interrupt.
So however it could be changed to identify those things because, it's not, I don't think it's a felony in Michigan, or it's a felony with a higher standard for a DUI felony. But in New York, there's a very low standard for a DUI felony. So this also doesn't identify that it's a felony related to Michigan. So if you're convicted of a felony, as you've identified in Indiana, because you took your grandma to the hospital, or in New York, because it was the second time you got nabbed for a DUI there, then you have a felony on your record, and it would disqualify you from serving on the city council, even if you're the most dedicated, citizen that we've ever had. So I think further definition, I don't think we should, I would say we shouldn't eliminate the idea of a felony, but we certainly should narrow it to those that would directly be related to a violation of the trust of the community and how you could do it or likely to.
Well, Jeff kept using the word charged, but here it says conviction.
Yeah.
So if you get convicted, you're going to be sentenced somewhere, and you're probably not going to be available to participate in it.
Yeah, sorry if I said charge, but I mean, I practice criminal law and job studies too. A lot of people get convicted even felonies, they don't do a day in jail.
Well, that was
It's
my,
not probation.
and that was my question. So conviction of a misdemeanor punishable by, is that the sentence you actually get, or is this a misdemeanor that has a range of sentencing?
The way it's written here would be what the maximum penalty. Right.
Right, but so that might not be good either, because, right, you got a misdemeanor, oh, we don't give any time for that, but we could have time, so that we get both.
So I think I have some different thoughts than Jeff here on C and D. And I mean, I think it's important to remember that these were voted on by the people at one point to include it. It doesn't mean obviously that we can't recommend, changing it now, but, you know, this was at one time the wisdom of, you know, the voters to say, you know, we don't want people who are violating the law to be making our laws. And I think that there's a certain logic to that we shouldn't discount. And I think I also disagree with Mark on limiting felony. I think that the more you limit it, the more the messier things get. You know, if you say conviction of a felony that violates public trust, then all of a sudden, because of how this operates, someone has to, or actually no one has to make a decision about what public trust means because it's done by operation of law. And that's not laid out. So then you're going to be getting involved in, depending on how much this person who violated public trust allegedly, or not allegedly, was convicted of violating public trust, wants to make a mess, you're going to have litigation. It's gonna just become a fight within the city, I would think. In my mind, it's easier to just say, if you violate the law and you're convicted of violating the law, then you shouldn't be on city council. I actually was going to recommend making an additional change to in addition to say anyone who's convicted of committing an assaultive offense also would not be allowed to serve on city council. A simple assault and battery is just a 93-day misdemeanor. Domestic violence is a 93-day misdemeanor under state law. And so I think that's something that I at least would want to have voters vote on. But again, maybe, those are my thoughts on that.
Interesting.
Jonathan, do you ever see in your practice, someone take a plea deal to something just to get through it and get it over with?
Yeah, of course.
Yeah, so people plead misdemeanors, but maybe they're not. Maybe they didn't do something, I don't know, yeah, they're not guilty, right? So that's where I'm going with this, and then, granted, this says in office. I guess misconduct in office is in office. I had thought part of my thinking is that historically, like, you know, certain people have been targeted.
The felony, I flag that, but if it's law in office.
Yeah, so there's some nuance to that, but you know, you mentioned this last time too, after you said someone could be targeted.
Oh, yeah, that's.
And that made me think too, yeah, I mean, someone could be targeted by a zealous prosecutor, and that prosecutor doesn't have to be in Lincoln County, it could be in Livingston County, or wherever, right? So I just go back to the big picture of like, we vote people in, we vote you out, unless, you know, some sort of nod, or whatever. But that's the democratic check, that's accountability, you can call somebody, and I actually kind of do maybe the idea of the council having the ability to remove someone for something that is maybe it's triggered by conviction or something too, I don't know, but maybe, yeah, maybe the council ought to be able to decide that too. You could have, yeah, I feel a little weird arguing, hey, somebody with a belly, look, keep on the council.
Well, I can see it on the ballot too, there's somebody, like, we're gonna report that you can be on
No, but
council
I think-
because of conviction.
I think people in this community could entertain, you know, have some ideas and sort of do that, but too, that maybe, you know, the council would say, this is our greatest council member here. Do we remove them, or if there's someone else remove them, or do we?
Well, part of it is the burden that you put on the elected to it. They elected someone in good conscience who is supposed to represent people, and they're over there committing potentially crimes. And now you have to place the burden back on the elected. Becoming someone is not an easy thing. It's a pretty arduous process. And so if someone's been convicted of a felony, we have to actually mobilize ourselves to get that person off the council because we think that maybe justice isn't fine.
Like Jonathan's point about the misdemeanors that we may find we would not find acceptable with a representative, but it's not at night. I can't believe that. So, but that's the thing though, right? That's what we're talking about. So that's the whole rule. Like we want to be stating our stuff. Thomas from.
And I have some hesitancy. I mean, as I thought more about the operation of law that we raised last time, I think I like it more because I think we're not allowed to talk about politics today. But, you know, processes to remove officials who have done wrong don't always work.
We can, it was only related to that particular.
Oh, okay.
Yeah.
Everything else is fair game.
Understood. So you don't have to look past 2020, January 6th to see that processes don't always work. That asking certain, asking city council to be judge, jury, and executioner on for another city council member, and when this person, their colleague, all of that, I think having it laid out, here's what you can't do in office, here are the rules you have to abide by. It's much cleaner, even if it does create a system where, there's, where something, and I'm struggling to come up with what to say, because I do appreciate your hypotheticals. It's just those are the extreme circumstances, right? That's not the common thing that somebody would be dealing with, if they were convicted of felony while in office, or if they were convicted of misdemeanor while in office.
And Jonathan, what if there's an appeal of this? What does that stop the conviction? With this language? They're not convicted, are,
I'm looking at Tony, that would be
Yeah,
interesting.
I'm looking at you.
Yeah.
I would think a conviction is a conviction.
Yeah, no, I mean, a conviction stands until, a conviction operates as a conviction even if you appeal it. And then obviously it gets reversed or it's overturned, then it's no longer a conviction.
So then someone could be removed from office and it turns out they've been exonerated. But that's on appeal.
But an appeal
Jill and then.
will be multiple years,
It's big.
always.
If someone embezzles $5,000 from their job, they should not be on city council, whether it's a felony, misdemeanor, or whatever.
That'd be,
Yes. Okay, $1,000.
that would be misdemeanor, yeah.
I mean, I just think that's we just can't have that.
That goes to what Mark said about breach of public trust. If you misuse public funds or
This is
bribery.
public. This is his employer, not his,
Not
not
a
our.
city, but
Yeah.
that's a problem.
Dale?
I was gonna ask, like, would this, preclude someone if they're convicted of, the felony, for example, in office, they lose their seat, would they be prevented then, let's say, like 10 years later from coming and like running for city council again?
I've seen that happen before, actually, where they will be convicted and subsequently serve their time and then subsequently re-engage.
That is allowed, couldn't be like under the, like how it's right now.
Yep.
So I got this little note here from him. Do you add language requiring a special election if members removed by 3.4?
So if I may, just to shed some light, so if there's a lot of debate on whether the validity of the items in 3.4, instead of filling a vacancy created by 3.4, you force a special election and let the voters determine whether the violations listed met their standard, and they have a choice to
Yes,
put it back
that
in.
makes it public.
Yeah.
That answers, that's
Right.
my solution.
That's a
This
great
is a
solution.
publicly, that's good.
That's a good idea. That's a really good idea.
Yeah.
Because if the people, like you're saying, if the people, this would be something that would be talked about a lot, if something like this were to happen.
Especially in these.
Yeah, especially, yeah, and if the people determine, I don't care, that,
Right.
then you're back in.
Overruled. But Jonathan, now what were you saying? I don't want to lose,
Yeah.
you're talking about,
Assaulted offense.
yes, assaulted offenses and maybe modifying this punishable by 6 months to articulate other crimes that maybe don't have 6 months.
Yeah, so, there's two in particular, simple assault and battery is a 93-day misdemeanor, so it's not covered by this. And domestic violence is also a 93-day, domestic violence first offense is also a 93-day misdemeanor, so not covered by this. I think it's probably easier just to, if we wanted to add those two in, to just single those out as 2 93-day misdemeanors as opposed to.
Didn't you call them assaulted or something?
So assaultive offenses, I did refer to that, I mean, the city code has disorderly conduct for fighting or jostling, for example, which would technically be considered an assault of offense,
So
but
there's things that don't fall on.
but I don't think, in my experience, is something that that is prosecuted in such a way so as to always require it to be an assault of offense.
Right.
Because, for example, technically, if you're engaged in a fight in self-defense under the fighting or jostling ordinance, that could still be a violation. Things like that. Issues that I've seen over the past few years that, so I think singling out specifically assault and battery and domestic violence might be a cleaner way to do it.
Tony, what are the charters that you worked on have, what's the comparison? What are other cities doing?
And these are really, it differs a lot. I think that's really a policy decision. You guys, I think that there certainly is the authority to do everything that you've discussed essentially though. But I think that, I don't know if there's any societal trend toward an understanding of people serving their time, because a lot of older charters will say, if you've ever been convicted of a felony, not well enough has ever been convicted of a felony. Well, in Flint, we had somebody that served their time for second-degree murder, got elected and ran on his rehabilitated status. And so I think this has a lot of the modern trends.
Just for clarification, yeah, when you talk about having a special election to replace, you're referring to C and D. In other words, the felony and the misdemeanor provision.
I interpret that's what Robert suggested.
Is that what you were talking about, Robert?
Yes.
Okay, those two. The other ones would remain the same.
If you are convicted of a crime, there will be a special election held to determine if you keep your seat.
Yeah.
Period.
Well,
If you choose to,
Right, not,
If
so
you
that makes it seem like it would be a recall
Right,
election,
if you
but
choose
I
to
think
run.
it's,
Right. Yeah, because, we got such a wide range. If you get in a bar fight and break somebody's jaw, my opinion is gonna be a lot different than if you stole from a nursing home. So, that's why I think that was a brilliant idea to have the voters decide.
Right, and it makes it public, and then we can choose to say, now you're a hero, Mark, because I heard the story about you taking your niece somewhere, but. I think that really happened.
It's no Mark at the slam, that project 2025, just like Mark's really prison, man.
But, yeah. Yeah, and then that lets
That's
us.
a bad one.
I was wondering that too.
Oh, man.
I don't know the scale, right?
That was from my elected official then, yeah.
So all this discussion, the old, or can we talk about the old? Because now all this
Let's
discussion.
just settle this part.
Yeah, I think we should. So is it, we want to add assaulted offenses? Let's just go with that. Do we want to have that in here as one of the misconduct and offer convicted of an assaulted offense? Do we want to have that in there?
Well, I think one other thing, I do agree with Jeff really strongly that we should say this is what misconduct in office is. So we should get rid of, I think, which includes, but it's not, or we should say as defined, as opposed to, so deleting which includes, but it's not necessarily limited to, and say misconduct in office, which is defined as 1, 2, 3.
It was not necessarily limited to opens up.
It's,
What is?
and when it's removal by operation of law, what are we talking about, right?
So-
So,
Yeah, again, I thought maybe remove them, I'm not hearing a lot of support on that, but, I'm in favor of leaving this as is with the special election. That sort of gives the person may not run, person may say, I'm so embarrassed, I'm gonna lose, because I embezzled from a nursing home. And no way. Or maybe they got in a bar fight after the event game in their town, and all sort of say, hey, she's a great councilman. I'm gonna reelect her.
So leaving 1, 2, and 3 there, not adding anything else, but having, and starting it off, and D is, this is what misconduct in office includes, is that what you're suggesting? And then a special election would be held? if removed from,
My recommendation would be to say misconduct in office, which is defined as 1, 2, 3, and then add for conviction of assault and battery or domestic violence.
So strike the not necessarily.
Right.
Yes.
But is that too limiting? Because there could be other things that we don't, I mean, when you start listing things, and things that are not included are not included.
Well, so the state treats domestic violence on the same level as driving with a suspended license. When it comes to misdemeanors, it's treated the same way as being a disorderly person. If we add domestic violence and assault and battery, then it was the conviction of a misdemeanor punishable by to at least 6 months in jail would still be included. The felony obviously still included, violating the PPO still included. Anything that constitutes misconduct in office still included. And so it's just adding what I think is, in my opinion, is missing from this list, which is those two charges.
I'm saying conceivably, that's exhaustive. That's what you're saying. This is exhaustive.
I think that, my opinion is this list should be exhausted.
It references other places in the charter, 3.13, it says it's not lost. I didn't look to see what else there may be others. Well,
so we'll remember that when we go. through this. I
There
think
may
that's-
be another reference up and down on officer.
I'm pretty sure that that was catch-all because we could.
Where would you put the special election? These are the reasons that there's a vacancy in office. Would you put that as a separate one, filling vacancies? If the vacancy is a result of misconduct in office, a special election would be held?
Yeah.
That sounds good, yeah.
But should we take a formal vote on whether we want to include that language or I don't know how.
Or
We're
will
opting to
come back in
proceed.
front of us at the next meeting.
Or that.
Yeah,
Yeah.
I think that's the time when we have his language.
Okay.
And if we can't,
Confirm.
Yeah.
That probably makes
Okay.
sense.
I'll just note that section 3.1A is ranked choice vote. So, I mean, I know it says that here, but that's.
That's where it'll go.
And I think, under state law, I don't know that we can make any change to any of the language that's on that.
Because it was already voted on in the ballot.
okay, so you'll come back with that too. So we have 4 ballot proposals and that's 5. I'm just gonna review those. We have the ranked choice voting, that's not a ballot proposal, that just has to be included for us to see that in there. Then we have the term of office, related to 3.3, the canvassing, so that will be another one. And, then we have the misconduct in office, we messed with that. And then 3.6, we're adding the misconduct for special election.
Yes.
So 1, 2, 3. So now we only have 4 ballot proposals on the first 3 instead of 13. Are we good?
At this point, change now, but the same as I've heard. Assault and domestic violence. Which one are we on?
I think I heard 3.4D4 would be added to say conviction of assault and battery or domestic violence. Was that the last?
That was my suggestion.
I just wanted to be
No,
clear.
I appreciate that. Typing a lot. Yeah.
Okay, and then, so, we left shortening and extending term of office. It has his or her, but we've covered that with the general thing. And then, the duty on leaving office is just returning all those possessions. Yeah, his and hers and there, but we're.
I want to talk about oath.
Huh?
I want to talk about acts. You could be removed for failure to take the oath.
Okay, the oath that we got, is not the oath that's being administered right now by the current city clerk. She recited to me, what she's been doing with all the police officers that have been there. And she says the same thing that they do for the president of the United States. I do solemnly swear or affirm. She
Or
uses both
affirm,
of those
so.
words in there.
How about those founding fathers, eh? No, seriously, I mean, that's from the founding documents, that they considered that.
So that is, this was, you can see that it was the library board of trustees. This was the previous, city clerk. And, I've been on, I was on the board of trustees for the library, and I only took this oath one time, and like a year ago after I'd been on it for a while. And she did every person, she did people that had been on there for a while. I don't know if it's because it was a board that isn't like a commission. It really has hiring, firing power as a library, and we'll get into that during the library, but I talked to Marie today, and she didn't know that they were swearing it in, so she's looking into that too. So when we get to the library, we'll see if that's right. But she goes, I always have them say, I do solemnly swear or affirm. And I said, but that's not what we. She goes, well, that's what I always do. So she's always done that. And so,
I think mine, I have in my office and I'll check, but I think it says swear, that was the successor.
The oath she gave me doesn't say it.
Doesn't say that.
No, it just swears,
That's the newest one. Yeah, I'll have to look at mine.
because she provided this for you guys too, but
Yeah.
what she gave me is this language here.
okay.
So I don't know where the affirm is coming.
So we just need, I'll get back to Marie and say.
Yeah, we need to update that.
Well, you can get back. to
Yeah,
me.
I'll
You
get
see
with,
where
that's right,
everything's-
I'll get back with it.
Well, so what I hear is there's a state law requiring the swearing of an oath. So
I think it's the state constitution, actually.
for elected officials, or you think it's because the board
Well, it
members
goes
are
federal, state, and then local.
elected officials, but also serving authorities.
The boards and commissions have never taken an oath of office. I think it was only this board of trustees was kind of new to me, so she was gonna look into that too. Because it's what we're doing.
Yeah,
So,
I hope we see some people getting called for not upholding their sworn oath. There's a lot of oath swearing if we're not using it as a tool. You run against somebody who's not upholding their oath, that just seems like a lot of activity. People aren't taking it seriously.
so we're good on this. Anything else on three? The party discussion. So we'll go to old business, which is the charter review status. So we will get chapter 3 back, chapter 1, 2, and 3 as our final things. If there's no changes to it, we'll just say no changes. I think we should vote that there's no changes proposed, just to have it on record that we reviewed it. Everyone okay with that? And then our plan for next time is 4, 5, and 6. And if there's anyone that needs any information, just send it on. The ballot resolutions are number 14 to 25. So if you want to review them yourself, I'll try to kind of have those ready to go over and help so we don't go backwards. But Honey is not going to be here next time, right?
I am going to be practicing. Times change.
Okay. All right. So then I don't have to cover that.
Sorry, Diane, say what you were saying about what were you saying to review the ordinance?
When Asia sent out all those ballot proposals for 97.
All the direct
So it's
changes.
14 to 25 apply to next week's meeting.
What's the total number, 15?
I think it's more than that. 33, 60 something, I think it is. Maybe I'm, but, we're already through 13 of them, so, hey,
Mark, did they all win by the same kind of percentage or
What's that?
those ballot proposals?
97.
No, I thought the,
58, 58.
I think they were pretty much the same. I mean, they weren't all the same by a long shot. But I don't think we had anything rejected.
No,
So.
they were all like 60 to 70%.
There was a lot, I guess, communication regarding what was going on. And when we finally produced the ballot proposals after the recommendation of the charter committee, there was a lot of fuss with regard to it. And you got to put it in context. We actually had newspapers then. So there was a lot more information that was available to the general.
I know, that's, I'm just like, I never remember that.
All right. We need a motion to adjourn if there's no other business.
I will to adjourn.
So moved by Dr. Veronica Wilkerson Johnson and supported by
Everybody.
I'll take Dr. Brandon Martinez. And all in favor, say aye. All opposed, same sign. Thank you all. It's really a good. This is a good start.
Situations, fairly